Here's a con law hypothetical that will focus your attention on some important analytical skills, skills that you will use in all of the different subjects, not just constitutional law. As always, let's take a look together at the call of the question. It reads, 1. What challenges, if any, under the U.S. Constitution may be brought against cities' landfill ordinance, and how should each be decided? Discuss. 2. May NAWT properly assert these challenges? Discuss. Well, question 2 appears to be a question about the threshold issues to civil litigation, standing, ripeness, and mootness. As we examine the question, we'll see that it turns out that question 2 is asking us about association standing. This is a very standard type of question. It is asked over and over again on essay questions throughout the United States of America. And so for association standing, remember that the basic elements are the members themselves would have to have standing. The suit has to be relevant or germane to the association's purpose, and then no individual participation of specific members will be required. That's the three-part test to association standing. It's one you ought to memorize, and it's one that's very commonly tested. And as you'll see, it's also a very thin issue. There's nothing more than these elements, and all you've got to do is connect the facts from the pattern to the elements and reach a conclusion. So question 1 is the more difficult question, because on its face it requires us to go fishing for various theories, whichever subject we're in, be it torts or contracts or property, or as it turns out here, constitutional law. Go to the top of the question with me, and let's issue spot it together. In paragraph 1, we meet city, a municipality, within state X. Notice in the very first sentence, we are told that they own and operate a landfill site. And the only reason they could tell you that fact, and I mean the only reason they can tell you that, is because we're going to be dealing with the Commerce Clause and we've got a market participant. The fact that this city owns this landfill gives it a greater degree of authority over it than if it was trying to regulate landfills that it did not directly own. We see that household and commercial non-hazardous waste are all disposed there. City finances the operation by charging fees based on a rate formula, and they give us the formula. We also see that the city's landfill is comparatively new, and it has a lot of unmet potential. In other words, there's room for a lot more trash. In paragraph 2, we meet Outco, and we also meet Inco. Outco is an out-of-state trucking firm. It hauls non-hazardous waste, and it's got contracts already. All right, stop right there. The fact that there is a reference to other contracts and the call of the question being as vague as it is, we are alert to spot a potential contracts clause issue. Now, as it turns out, I am somewhat hostile to these plaintiffs across the board, but I still want to think like a plaintiff's lawyer enough to be able to spot all of the possible theories. On an essay, that's part of the job in any jurisdiction in the country. When we get a call of the question like this, what challenges, if any, may be brought, what they're looking for is your ability to spot the issue and, in particular, identify as many theories of liability as possible. Now, one organizing principle. As you write about these various theories, the basic approach ought to be lead with whatever you think the strongest theory is, and then discuss each of the other theories in a descending order of importance. And think about it. That's really just common sense. That's how we do it in court. If a prosecutor is filing a complicated case against a defendant, they will lead with the homicide charge, and the possession of marijuana charge is going to be a lot lower on the list. Similarly, on the bar exam, typically in any question involving a plaintiff and a defendant, the plaintiff ought to lead off with the strongest theory of liability, unless there's a good reason to do otherwise. So, in paragraph 2, we meet Outco, and then we meet Inco. Inco is a state X trucking firm with offices within the city, and it hauls hazardous waste, non-hazardous waste from within the city and from outside the city as well. Then, and other, we learn a lot about what Inco does. Now, in paragraph 3, we see a new ordinance passed by city, and that's what we're being called to discuss challenges to in the first call of the question. Look carefully at paragraph 3. Within this paragraph is one of the most important organizational lessons to learn. A thorough analysis of this statute requires breaking it up into two different pieces. The first piece is the outright ban on out-of-state waste. And then the second part of this law is the higher fee for waste that comes from the same state but from outside the city. So there are two separate aspects to this bill, and we've got to talk about each one of them separately. And so the better organized answers will have rigorous discussions of each of the two aspects of this ordinance. Then in the last paragraph, we get what is a stereotype association standing question. There's nothing about this question that's remarkable at all. It's generic. Questions exactly like this one, with just a change of name, have appeared on bar exams for decades. And there's really only one way they can test it, and that's the way they've presented it here. We meet NAWT. They represent waste haulers. Both of these waste hauling groups are members, OUTCO and INCO, and NAWT wants to challenge this action. The second call of the question asks, can they do it? The answer is mostly yes, although with one tiny little bit of fine print, we'll see that they can't bring one aspect of one of the theories. Now, what the examiners are looking for here is quantity of theories and quality of organization. We'll see hypotheticals that are basically self-organizing, but this isn't one of them, and that's one of the parts of this exercise that makes it more difficult and also a little bit more interesting for our purposes. Now, obviously, the key constitutional challenge that a plaintiff is going to bring to either aspect of this ordinance is going to arise from the Commerce Clause. And we've already spotted that there is a Contracts Clause issue as well. Turn the page and take a look at the outline of issues that I've presented. Let's look at that outline together and let me flesh out the analysis a little bit. In order to explain the analysis well, we have to explain where the city gets its power. Where does its authority come from to pass these ordinances or this detailed ordinance in the first place? And the answer is the police power. That's the primary source of authority for state and local governments. And then in the outline, you'll see that very carefully I analyze separately the ban of out-of-state waste and then the higher rate for non-city waste. And we see with regard to the Commerce Clause that the defendant, city, is not allowed to unreasonably discriminate or to unduly burden interstate commerce. Well, let's consider first the ban on out-of-state waste. Is there a discrimination? Answer, yes. There's a total ban. That's about as much of a discrimination as you could possibly imagine. Is it an undue burden? Answer, probably not, based on a complete analysis of the facts. We know that landfill space is scarce. The more scarce it is, the more likely it would be that this ordinance would unduly burden interstate commerce. But, to my way of thinking, the fact that the city is a market participant, that it owns this landfill, gives it much more authority than it would have otherwise. And I would represent that that authority would extend to having the power to ban out-of-state waste altogether. Now, a reasonable argument could be made that reaches the opposite conclusion. And for the purposes of this discussion, I'm not trying to tell you that I have a monopoly on reality or truth or the correct answer. But here, I really do think the better answer is the fact that we've got a market participant municipality is enough to overcome the contest of the part of the ordinance that bans out-of-state waste. Now, I suggest another possible discussion with regard to this out-of-state waste ban based on the Equal Protection Clause. Why do I raise the Equal Protection Clause at all? Well, the call of the question's asking us for theories. They're looking for our ability to come up with facially sensible constitutional law theories. And the Equal Protection Clause is a valid theory to consider. It's not a successful theory, but we've got a clear discrimination. And anytime there's a discrimination under the law and we are being asked about constitutional theories, an obvious theory is equal protection. Now, it very well might have crossed your mind and you might have decided to leave it out because you see that this is merely an economic regulation. It doesn't have anything to do with a fundamental right or a suspect class. That's the analysis that belongs in the answer. To raise the issue since we've got a discrimination and then to carefully explain why it doesn't apply. I don't lead with that theory because it's clearly a Commerce Clause theory. Instead, I talk about it as a 14th Amendment equal protection issue. And then, finally, with regard to the ban on out-of-state waste, I go to Article 4, Section 2, and the Privileges and Immunities Clause. And the reason I raise this issue is to directly answer an aspect of the second call of the question, which I would include right here where it belongs in an analysis of the ban on out-of-state waste, and that is privileges and immunities. Well, privileges and immunities only applies to flesh and blood citizens. It would not apply to an association. So technically, NAWT could not bring an Article 4, Section 2 privileges and immunities claim. Still, we bring it to the attention of the examiners because, once again, we've got a fact that triggers that possible theory, a discrimination by one state on another. That's a potential privileges and immunities clause issue. Then we turn to the analysis of the higher fee for out-of-city waste, and again, it's a Commerce Clause case principally. We examine it with reference to the analysis that we've considered before, and if you agree with me that cities' status as a market participant entitles them to ban out-of-state waste altogether, it's likely you'd agree with me that the same fact, that we've got a market participant, allows the city the authority to charge a higher than ordinary fee. Now, if you agree for a moment to disagree with me, and you say, wait a second, we've got a scarce resource here, landfill space, and that fact is enough to create an undue burden on interstate commerce. Under the facts presented here, I couldn't authoritatively say you're wrong, but I think that the majority answer, the stronger analysis, is that cities' status as a market participant is enough to get them off the hook for potential Commerce Clause liability. With regard to the higher fee for out-of-city waste, I also consider equal protection. We've got a discrimination. It's, again, an economic discrimination that has nothing to do with a fundamental right or a suspect class. And then, with regard to the higher rate, I talk about the Contracts Clause briefly because both INCO and OUTCO have existing contracts. And the fact that this ordinance interferes with that contract does not, under these facts, give rise to a Contracts Clause claim because there's no direct intent to interfere with these contracts. This is a regulation of an important part of cities' infrastructure. It isn't designed to go after previously existing contracts. So that's it for the hard part of the question, the first call with regard to the con law theories. What's hard about this is we've got to come up with all the theories, and we're being judged based on how thorough a job we can do. So I think you might agree with me, you'll learn a lot more about con law by seeing how it's tested. Notice how the Equal Protection and Privileges and Immunities Clause issues are not being spoon-fed to you. You've got to know enough about how to think about this subject to recognize them. So we finally turn to the association standing issue, and this is much easier stuff. It's easy to spot, and it's easy to analyze. We see that the members of NAWT would have standing as individuals. Both INCO and OUTCO easily could challenge this ordinance on their own. They don't need NAWT to do it, but NAWT is well placed to be helpful to them. Obviously, the suit is relevant to the association's purpose because this is an association of waste truckers, and the fees that they pay obviously affect everybody that's involved in this association. Furthermore, the issues are academically plain. There aren't really facts in dispute. The statute's on the books. It's hurting the members of this association. They're challenging it. The members don't have to come to court to explain anything special about their circumstances. So the bottom line is NAWT has standing to pursue all of the theories except the Article 4, Section 2 Privileges and Immunities claim. That claim about the total ban is not going to be represented by NAWT because they're not a flesh and blood citizen. And that wraps up a consideration of about as complicated a Commerce Clause issue as you're likely to see on any exam. And I think as you do practice on the MBE, you'll see fact patterns directly analogous to this one, which will focus your attention on all of the different subparts of this issue.